The billing alert hit my inbox at 2:47 a.m. on a Tuesday, flagging 17 notarized affidavits I'd never authorized for filing. I'm Jonathan Stonegate, 42, contract attorney specializing in personal injury cases at our plaintiff side firm here in West Palm Beach. 20 years of practice taught me to trust my instincts. Something was wrong. The case management system showed my digital signature on documents I'd left in draft form. Each affidavit bore timestamps from last weekend, when I was in Miami deposing witnesses for the Henderson slip and fall case. The notary stamps looked legitimate. The formatting matched our firm's standard templates perfectly. But I hadn't touched those files since Thursday. I pulled up the access logs. My user credentials had been active Saturday at 11:23 p.m., Sunday at 3:15 a.m., and Monday at 7:41 p.m. The IP address traced back to our office network. Someone had used my login information to finalize and submit sworn statements I'd deliberately left incomplete. The affidavits concerned 3 separate cases: a product liability claim, a medical malpractice suit, and a wrongful death action. Each document contained witness testimony I'd been carefully crafting. Each statement had been altered, subtly, professionally, but definitively changed from my original drafts. The product liability affidavit now included technical specifications I'd never researched. The medical malpractice statement contained expert opinions from a doctor I'd never contacted. The wrongful death testimony referenced that didn't exist in our discovery files. Someone had accessed my work, enhanced it with fabricated details, and submitted it to opposing counsel as legitimate sworn testimony. The modifications were sophisticated enough to pass casual review but detailed enough to potentially win cases. I checked the firm's notary log. Xavier Forrester had notarized all 17 documents. Xavier, my law school roommate, my closest friend at the firm, the partner who'd recommended me for this position 3 years ago. The same Xavier who had master-level access to our case management system and knew my password habits from countless late-night strategy sessions. The billing records showed each notarization had generated a $50 administrative fee, charged directly to client accounts. 17 affidavits. $850 in unauthorized charges. But the real concern wasn't the money, it was the perjury implications. If opposing counsel discovered these fabricated elements during cross-examination, our clients would face sanctions. Our firm would face bar complaints. I would face disciplinary action for submitting false sworn statements, even though I hadn't actually submitted them. My phone buzzed. Text message from Xavier. "Early morning again? You need better work-life balance, John. Coffee later?" He was monitoring my system access in real time. The betrayal started 18 months earlier, though I didn't recognize it then. Xavier Forrester had called me on a Tuesday evening in March, his voice carrying that familiar law school confidence. "John, I've got something perfect for you. Contract attorney position at our West Palm Beach office. Plaintiff side work. Exactly what you've been wanting." I'd been struggling with solo practice debt and mounting overhead costs. The offer seemed providential: steady income, established client base, partnership track within 2 years. Xavier painted it as a temporary solution that could become permanent. "You'll handle the heavy lifting on major cases," he'd explained during our lunch meeting at City Place. "I'll supervise, but you'll have significant autonomy. Think of it as rebuilding your practice with our infrastructure support." The arrangement felt natural. We'd been roommates at Florida State Law, study partners through the bar exam, occasional golf partners afterward. Xavier had always been the networker, the one who landed at established firms while I'd chosen the independence route. Our first case together involved a construction accident, a crane collapse that injured 4 workers. Xavier assigned me the discovery phase while he handled client relations and settlement negotiations. The case settled for $2.4 million. My research and depositions had been crucial to the outcome. "You've got the analytical mind for this work," Xavier had said, reviewing my witness preparation notes. "I handle the politics, you handle the substance. Perfect partnership." The pattern continued through summer and fall. Xavier would bring in cases, assign me the research and documentation work, then present the results to clients and opposing counsel. I prepared opening arguments that Xavier delivered. I drafted motions that Xavier filed under his signature. The arrangement bothered me initially, but Xavier's explanations made sense. You're rebuilding credibility after the solo practice issues. Let me be the face while you prove your value. Partnership decisions happen in January. This is your audition period. By December, I'd worked on 12 major cases. My research had contributed to settlements totaling $8.7 million. I'd prepared witness statements, expert testimony summaries, and damage calculations that formed the backbone of our litigation strategy. The firm's holiday party was held at the Breakers. Xavier introduced me to senior partners as our secret weapon and the researcher who makes magic happen. I felt valued, appreciated, finally part of something successful. Then came the January partnership meeting. We've decided to extend your contract another year, Xavier announced in his office. Partnership consideration will happen next January, assuming continued performance. No explanation, no feedback, no discussion of my contributions to the firm's most successful year in recent memory. What about the cases I've worked on? I asked. The settlements, the research, the client development? Xavier's expression shifted slightly. John, you've done excellent support work, but partnership requires more than research skills. It requires client relationships, business development, courtroom presence. I've been preparing for courtroom work. You said I'd get trial experience this year. And you will. But we need to see sustained performance over multiple years. The conversation felt rehearsed, like Xavier had practiced deflecting my questions. I left his office with growing suspicion about the partnership timeline and my actual role in the firm's success. February brought the Morrison case, a medical malpractice claim involving surgical complications. Xavier assigned me the complete case development while he traveled to conferences. I interviewed witnesses, reviewed medical records, consulted with expert physicians. The case required extensive affidavit preparation, 7 witnesses, each requiring detailed sworn statements about the surgical procedure, post-operative care, and resulting complications. I spent 3 weeks crafting precise language that captured each witness's testimony while avoiding potential cross-examination traps. Xavier returned from his conferences as I finished the draft affidavits. Excellent work, he said, reviewing my documents. I'll handle the finalization and submission process. 2 weeks later, opposing counsel filed a motion challenging our witness statements. They claimed our affidavits contained technical medical details that exceeded our witnesses' expertise. The motion included specific examples of language that seemed professionally enhanced beyond typical witness testimony. I reviewed the submitted affidavits. They contained medical terminology I'd never written, technical specifications I'd never researched, expert opinions from physicians I'd never contacted. Someone had taken my careful draft work and enhanced it with fabricated details. The Morrison case wasn't isolated. I began reviewing other recent submissions, comparing my draft files with the final documents submitted to courts and opposing counsel. The pattern was consistent. My original work, professionally enhanced with details I'd never written. The Hendricks product liability case. The Patterson wrongful death claim. The Williams construction accident. All contained my foundational research enhanced with fabricated supporting details. Each enhancement was subtle enough to avoid immediate detection, but substantial enough to strengthen our legal position. Someone with sophisticated legal knowledge was systematically improving my work before submission. The billing records revealed the administrative pattern. Each enhanced affidavit generated notary fees, filing charges, and administrative costs that were billed directly to client accounts. The amounts were small, $50 to $100 per document, but the frequency was concerning. More troubling was the potential for discovery. If opposing counsel identified the fabricated enhancements during depositions or cross-examination, our clients would face perjury accusations. Our firm would face sanctions. I would face disciplinary action for submitting false sworn statements. Xavier's access to my work files was unrestricted. As supervising partner, he had master-level permissions in our case management system. He knew my research methods, my writing style, my password habits from countless late-night collaboration sessions. The timeline aligned perfectly. Each case where I'd found enhanced affidavits corresponded to periods when Xavier had been traveling or attending conferences. Times when he would have needed to finalize my work remotely, without direct consultation. They let me present the opening argument in the Richardson case, a slip-and-fall claim involving a grocery store chain. Xavier had been called away for a family emergency, leaving me to handle the hearing alone. Standing before Judge Martinez, delivering arguments based on my own research and preparation, I felt the confidence I'd been missing. The opposing counsel's objections seemed weak against the I'd assembled. The judge's questions revealed genuine interest in our legal theory. We won a favorable preliminary ruling. The grocery chain's insurance company contacted us within hours about settlement discussions. Xavier returned the next day, reviewing the hearing transcript with obvious satisfaction. "Excellent work, John. This is exactly the kind of performance that supports partnership consideration." But his praise felt hollow now. I'd been delivering this level of work for 18 months, only to have it presented under his signature and credited to his legal strategy. The enhanced affidavits represented something more serious than credit theft. They represented systematic fraud that could destroy careers and harm clients. I needed proof before making accusations. Xavier was a senior partner with firm-wide influence. I was a contract attorney with no permanent status. Any confrontation would require irrefutable. The case management system logs would show access patterns, document modifications, and submission timestamps. If Xavier had been enhancing my work, the digital trail would reveal when and how he'd made the changes. The case management system required administrative credentials to access detailed audit logs. I couldn't request them without triggering questions from IT support, but Valentina Chen had those credentials. As the firm's compliance officer, she monitored document integrity and billing accuracy across all practice areas. Her access included timestamp analysis, user activity reports, and modification histories. I found her in the compliance office at 7:30 p.m., reviewing quarterly billing summaries under the harsh fluorescent lights. "Valentina, I need your help with something sensitive." She looked up from her computer screen, studying my expression. "What kind of sensitive?" "Document modification patterns. I think someone's been altering my work after submission." Her fingers paused over the keyboard. "That's a serious allegation, John. You're talking about potential fraud." "I know. That's why I need the audit trail before making any formal complaints." She gestured to the chair beside her desk. "Show me what you've found." I explained the enhanced affidavits, the timeline correlations, and Xavier's convenient absences during case developments. Valentina listened without interruption, occasionally making notes on her legal pad. "The Richardson case hearing," she said finally. "You presented alone because Xavier was handling a family emergency?" "That's what he told me. Our travel expense system shows no emergency travel reimbursements for Xavier during that period. He was in the office the day before and the day after your hearing." The lie felt like a physical blow. Xavier had deliberately avoided the hearing, allowing me to present arguments based on my own work, while maintaining plausible distance from the enhanced. Valentina pulled up the case management interface, navigating to the audit logs section. "What specific documents do you want me to examine?" "Start with the Richardson affidavits. Then check the Morrison case files and the Henderson discovery responses." Her fingers moved across the keyboard with practiced efficiency. The audit logs populated on her screen, showing user access, modification times, and document version histories. "Here's something interesting," she said, pointing to a series of entries. "The Richardson affidavits show 3 separate modification sessions after your initial draft submission. The timestamps revealed the pattern clearly. I'd submitted draft affidavits at 6:15 p.m. on a Tuesday. Xavier had accessed the documents at 11:45 p.m. the same evening, making substantial revisions that enhanced witness credibility and added supporting details I'd never written. Look at the modification metadata, Valentina continued. He's not just editing your work. He's adding entire paragraphs, strengthening witness statements, and inserting factual claims that weren't in your original research. The Morrison case showed identical patterns. My conservative, factual affidavits had been transformed into compelling narratives that pushed ethical boundaries while remaining technically defensible. "This is systematic document fraud," I said. "He's been doing this for months." Valentina printed the audit reports, organizing them by case and chronological order. "The pattern is consistent across 14 different matters. Always late-night modifications. Always enhancing witness credibility beyond your original research. What's our next step? We report this to the State Financial Crimes Investigation Unit. Document fraud in legal proceedings falls under their jurisdiction." She reached for her phone, dialing a number from her contact list. "Claire Bishop handles professional accountability cases for the State Investigation Unit. She'll want to see this immediately." The call connected after 2 rings. Valentina explained the situation in clinical terms, avoiding speculation while presenting the documented facts. Claire Bishop agreed to meet us at the office within the hour. Professional Accountability Officer Claire Bishop arrived at 9:15 p.m., carrying a leather briefcase and digital recording equipment. She was younger than I'd expected, probably early 30s, with the focused intensity of someone who'd built her career on exposing professional misconduct. "Mr. Stonegate, I understand you've discovered of document manipulation within your law firm?" "That's correct. My colleague has been systematically altering legal documents I've prepared, enhancing witness statements, and adding factual claims without my knowledge or consent." Claire Bishop reviewed the audit logs methodically, asking detailed questions about each case and the timeline of discoveries. She photographed the computer screen, documenting the metadata and modification patterns. "This represents a clear violation of professional conduct rules," she said. "Fraudulent enhancement of witness statements can invalidate legal proceedings and expose clients to sanctions." "What happens next?" "I'll initiate a formal investigation. We'll need to examine the original case files, interview affected clients, and determine the scope of potential harm. Mr. Forrester will be notified of the investigation and given opportunity to respond." The investigation moved quickly. Claire Bishop's team examined 18 months of case files, identifying systematic patterns of document enhancement across multiple practice areas. They interviewed clients whose cases had been affected, explaining the potential impact on their legal proceedings. Xavier was suspended from practice pending the investigation's completion. The firm's managing partners called an emergency meeting, reviewing potential liability and client notification requirements. I testified before the State Bar's disciplinary committee, presenting of the document manipulation and its impact on case outcomes. Xavier's attorney argued that the enhancements had benefited clients and hadn't caused measurable harm. The disciplinary committee disagreed. Xavier received a 2-year suspension from practice, along with mandatory ethics training and supervised probation upon reinstatement. 3 affected cases required relitigation with corrected. The firm faced civil liability from clients whose cases had been compromised. Settlement negotiations consumed months of partner meetings and insurance company discussions. I helped other attorneys review their case files, identifying additional instances of unauthorized document modification. The investigation expanded beyond Xavier's direct involvement, revealing systemic weaknesses in the firm's document control procedures. The experience changed how I approached legal practice. Trust required verification. Collaboration demanded transparency. Professional relationships needed clear boundaries and documented accountability. 12 months later, I opened my own practice in downtown West Palm Beach. The office occupied the 15th floor of a glass tower overlooking the Intracoastal Waterway. Sunlight streamed through floor-to-ceiling windows as I reviewed partnership agreements for a new client. The transition from large firm practice to solo work had been smoother than expected. Former clients followed me, trusting my commitment to ethical representation. Word spread about my role in exposing the document manipulation scandal. Other attorneys referred cases, knowing I maintained strict professional standards. My practice focused on complex litigation and professional liability defense. I represented attorneys facing disciplinary proceedings, understanding firsthand how quickly trust could erode and careers could crumble. Each case reminded me why transparency mattered in legal practice. The state bar had implemented new document authentication requirements following Xavier's case. Law firms now maintained detailed audit trails for all case materials. Digital signatures required multi-factor authentication. Document modification logs became mandatory for court filings. Xavier completed his suspension and returned to practice under supervised probation. He worked at a small firm handling routine matters, rebuilding his reputation slowly. We never spoke again, but I monitored his disciplinary status through public records. Trust, once broken, rarely healed completely. Claire Bishop had been promoted to Senior Professional Accountability Officer. Her investigation of the document manipulation case became a training example for other investigators. The thoroughness of her work had prevented similar schemes at other firms. I maintained relationships with former colleagues who had supported me during the investigation. Valentina Forrester joined the state attorney's office, prosecuting white-collar crimes. She often consulted with me on cases involving attorney misconduct. The firm where Xavier and I had worked eventually dissolved. Partner departures and client defections following the scandal made continuation impossible. The remaining attorneys scattered to other practices, carrying lessons about the importance of internal controls and ethical oversight. My new practice thrived on principles of transparency and accountability. Client files remained accessible through secure portals. Document modifications required written authorization. Billing practices followed strict protocols with detailed time entries and expense documentation. I advocate for proper exit clauses in law firm contracts, having learned how quickly professional relationships can deteriorate. Clear terms protect all parties when partnerships badly. Evening light reflected off the water as I finished reviewing the day's correspondence. The office felt peaceful, free from the suspicion that had consumed my final months at the old firm. Building something new required patience, but the foundation felt solid. The phone rang occasionally with referrals from satisfied clients. Each case represented an opportunity to demonstrate that legal practice could maintain both excellence and integrity. The work felt meaningful again. It was finally over, and the silence felt earned.